And the court will sentence you to 14 months in the state jail facility and give you credit for any time served.
Paul Carpenter faced the judge for drug possession, state jail felony, less than a gram. He came in expecting probation or maybe a light sentence, but his past caught up fast. Paul's attorney pleads his case. Rehab program, recovery classes, changed life, and hope for a second chance. The prosecutor fires back, long criminal record, gang affiliation, and a repeat cycle of mistakes. The judge considers it all and delivers a verdict: 14 months in jail, no more second chances right now. Is this justice for Paul, punishment, or a real shot at change? You're about to see the exact moment everything turns.
All right, the court is calling 2025 CR 008-179 State versus Paul Carpenter. Can I have parties announce?
Melissa Alvin for the state.
Robert Porter for Mr. Carpenter.
And are you Mr. Carpenter?
Yes, ma'am.
Counsel, have you received all discovery?
I have, Your Honor.
And did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Carpenter, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Carpenter, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge, I did.
You're charged with possession of a controlled substance penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, it appears that you're going open to the state. So the full range of punishment is open to the court. Do you understand?
Yes, ma'am, I do.
Do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Carpenter, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, I am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is open. The only thing that you all have agreed to is that there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Yes, Your Honor.
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Then how do you plead to the offenses charged?
I believe guilty, ma'am.
Any evidence?
State Office into Evidence States Exhibit 1.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, just 1 second. Okay, they're still there. All right, again, did you understand, by signing that, you're giving up your rights to a jury trial, you're giving up the rights to cross-examine witnesses and the right to remain silent?
Yes, ma'am.
So what that means is that the state is going to be presenting evidence in the form of witnesses' statements and police reports, but there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, can I reserve time to say?
Your Honor, we're asking that you impose, if not the max, something close to the max. This case is a state jail felony. However, it could have been indicted as a repeater based on his state jail repeater based on his criminal history. We could have re-indicted it. We chose not to work it out this way, or filed notice of intent to speak. The enhancement. He has a very lengthy criminal history, and we think that would be a fair resolution.
And what is the criminal history?
He has been convicted of interference with an emergency phone call, failed ID. That looks like a Class B failed ID. A bird cab. He did 5 years for a bird cab in 2011. Looks like there were 2 counts of that, and they ran concurrently. He also was convicted of a second-degree drug case, 4 to 200. He did 30 months confinement for that. Another failed to ID fugitive, a less than a gram that he did 9 months for. Fraud use that he did 9 months for in 2018. A UUMV that he did 8 months for in 2019. Another fraud use in 2022, he did 2 years for. And several other cases that, a few other cases that are still pending and I think in flux, as far as I know. And I think there's reference to them in the police report that we tendered in the STIPs.
I don't know where to start, but I'm gonna start with this. It's 0.14 gram. This same district attorney's office, just a short time ago, was dismissing cases under 0.25. Now they're stepping in and asking the court to do jobs that they didn't do. Having said that, Judge, yes, he has a lengthy criminal history, but we're not here for those cases. We're here for this meth case. He's pled guilty in front of this court, and that's what he's did. He hasn't been sitting in jail doing nothing. He's been in jail actually 203 days. And what he's been doing is he took the mental health recovery program. That's number one, because as the state had pointed out to me, he at one time was considered a gang affiliated. By taking that course, he is no longer gang affiliated. That's why he's also dressed in orange. The course he took was that mental health recovery program, which helps you to handle situations, communication skills. It was AANA to get sober. They also put him on Suboxone to help him with his drug treatment. His mother right now, Judge, was going to be here today, but she had surgery on the 14th, back surgery place, so she couldn't be here. We're respectfully requesting, Judge, that we're here for a state jail felony of 0.144, and I'm not belittling that, other than it's the smallest amount I've seen in a long, long time. We're respectfully requesting that this court sentence it in the lower range.
All right, so I'm reading the police report, and I will tell you, Mr. Carpenter, I do consider criminal history, because I always tell people criminal history is like a credit report, in the sense that, should I loan this person money, will they be able to pay it back? Let me look at their credit history. And criminal history is sort of like that, in the sense of, should I give this probation? Should I not give them probation? What should I sentence them to? Because you look at it to see how they've done in the past, right?
Yes, ma'am.
So here's my question, and nobody's answered it. Does he have, based upon what I'm reading, are there cases that are still pending or not?
I think, Judge, well, I'll let the state go.
Sorry, that's why Rick is here, Your Honor, because those were family violence cases, and so he was gonna speak on that.
Yes, the defendant does have 2 burglary charges and a repeat VPO charge pending that, unfortunately, due to victim uncooperation at this time with our office, they have not yet been indicted. We are still within statute though, so at some point in the future, they may get indicted, but unfortunately, it doesn't appear that in the immediate future will be indicted on those.
Which is why, Judge, if I may, which is when I took over this case in the courts, I was threatened with all these cases. They have done nothing with these cases. And what they're doing now is stepping in and saying, Judge, please do the job that we can't do.
All right. All right, this is what the court is going to do. The court, as previously stated, the court is finding you guilty. The court is recommending, excuse me. The court is recommending the therapeutic community. There's to be no contact with, yeah, I thought I didn't see it. The complainant's name is not even fully in the report. So who's the complainant?
In this case, it's the state of Texas.
No.
That,
I mean,
that
for
wasn't the
the-
only report, Your Honor, but since we were only proceeding on the drug case, I didn't include the entirety of the rest of the case.
And the court will sentence you to 14 months in the state jail facility and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, yes, Judge, I did.
All right, because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Judge.
All right, we can go off the record. So, Mr. Carpenter, I want to let you know that I really listened to your attorney's argument, and your attorney did make good arguments. But you are going to have to continue on the path that you're on. Otherwise, you're going to end up right back here. You understand?
Yes, Judge.
All right, good luck to you, okay?
Yes, ma'am. Thank you.
You're welcome.
That's the correct one.
All right, thank you. Who else is ready?
Billy Reynolds,
Case.
page 5, one down.
Billy Reynolds. Yeah.
Good afternoon.
Good afternoon.
Paul Carpenter leaves court heading for 14 months in jail. He tried to change, but his past was impossible to ignore. Did he deserve tough punishment, or did rehab mean more than his record? Let us know if you think he got justice or just judgment. Comment below. Like and subscribe for every twist inside real viral courtrooms.